Welcome to the Deep Dive, your shortcut to being genuinely well-informed. Today, we're tackling a case that's been in the headlines for decades.
It's a huge one.
We're talking about Glossip v. Oklahoma. It's a capital murder case, but it's really a story that tests the absolute limits of due process.
It really is. I mean, we're talking about a situation where Richard Glossip was convicted, sentenced to death, not once, but twice, based almost entirely on the testimony of the man who actually committed the murder, Justin Sneed.
And here's the hook. This is what makes this case, just so unique and frankly so disturbing.
Right.
After all these years, the current Oklahoma Attorney General looks at the case files and says, wait a minute. He admits the conviction was deeply flawed and actually supports Glossip's request for a new trial.
Which is almost unheard of.
When the government itself says a man on death row was convicted unfairly, that's when you know something has gone terribly, terribly wrong.
Absolutely. And from a legal perspective, what we're looking at here is a deep dive into the 14th Amendment's Due Process Clause. Specifically, it's about a standard from a 1959 case, Napoo v. Illinois. And it basically says prosecutors have an absolute non-negotiable duty to correct false testimony.
Even if the lie isn't about the murder itself.
Even if it just goes to the witness's credibility. That's the key.
So our mission today is to unpack this whole journey, from the murder in 1997 all the way to this recent SCOTUS ruling. We need to get into the withheld evidence, the procedural roadblocks, and why the Supreme Court finally said the whole process was, well, contaminated. Let's start at the beginning. 1997. The victim is Barry Van Treese. He owned a budget motel, and he was beaten to death with a baseball bat by the motel's handyman, a man named Justin Sneed. Richard Glossip was the manager.
So at first, Glossip's statements to the police are a little confusing. But he eventually tells them that Sneed confessed to the killing.
And when the police pick up
Sneed immediately flips the script. He says Glossip was the mastermind, that Glossip told him to do it, supposedly to steal money, or maybe because Glossip was afraid he was about to get fired.
And this is the dynamic that you have to keep in your mind through this whole thing. Glossip always maintained his innocence, refused every plea deal.
While Sneed, the confessed killer, gets a deal to avoid the death penalty in exchange for his testimony against Glossip.
And that testimony is the only direct evidence.
It's the whole case, which is why his credibility is everything. And it was a shaky foundation from the start. Glossip's first conviction was actually overturned for ineffective counsel.
Because the corroborating evidence was just that weak.
Exactly. The court called it extremely weak. And even by the second trial, in 2004, Sneed's story is shifting. He's inconsistent about Glossip's motive.
But there was a more alarming change, right? Something about the murder weapon.
Yes. It wasn't until the defense confronted him with the medical examiner's report that Sneed finally admitted he didn't just use the bat. He'd also tried to stab Van Treese with a pocket knife.
A detail he'd denied before. To the police and in the first trial.
A critical, violent detail. And that history of lying, of minimizing his own role, that really sets the stage for the big constitutional violation here.
Okay, so let's get to that. This is where that legal rule, the Napoo rule, it just slams right into the human part of this story.
It does. So during the second trial, Sneed is on the stand, and he gets asked about medication he's taking in jail.
And what does he say?
He tells the jury he'd asked for Sudafed for a cold. But then he says he was given lithium for, this is his quote, some reason. And then crucially, he adds, I never see no psychiatrist or anything.
So he's painting a picture of just, a simple mix-up.
Exactly. A simple guy got the wrong pills by mistake.
But the truth was something else entirely. And it took years and a huge independent investigation to find it in these documents they called Box 8.
The truth was just devastating to the prosecution's story. Sneed had, in fact, been diagnosed with bipolar disorder, and he'd been prescribed that lithium by a psychiatrist, a Dr. Tromka, specifically for that condition. I mean, lithium is only used for serious mood disorders. So the whole story about the Sudafed, about never seeing a doctor, it was a complete fabrication.
Which brings us to the Napoo question. Did the prosecution know he was lying?
The evidence is overwhelming that they did. Later investigations found the head prosecutor's own notes.
Motherman's notes.
Right. And in those notes, from before Sneed testified, were the words lithium and Dr. Trumpet. A clear misspelling of Tromka.
So they knew their star witness had a serious mental health condition, and they just let him tell the jury he had a cold.
They allowed the lie to stand uncorrected.
I don't get it. I mean, in a death penalty case, why does a lie about his health matter so much? Does a jury really care if he's bipolar or had a cold?
Legally, it's the whole ballgame. This is what we call materiality. The Supreme Court said the jury's assessment of Sneed was necessarily determinative.
Because he was the only link.
The only one. The prosecution's whole theory was that Sneed was this passive Rottweiler puppy, as they put it. Harmless on his own, but violent when ordered by Glossip.
But the moment you introduce bipolar disorder and you add in his admitted heavy meth use,
Methamphetamine, crack gas.
well, suddenly he's not a puppy. He's a volatile, independently violent person.
Exactly. The defense could have argued that Sneed was prone to impulsive violence all on his own, which just shatters the prosecution's entire motive theory.
Plus, the lie itself is a problem, if he's willing to lie about that.
A lie is a lie no matter what its subject. That's what the court said. If he'll lie about his own health to make himself look better, why should you believe a single word he says about Glossip?
And there was another huge problem with the state's case, wasn't there? The motive itself, the whole embezzlement idea.
The crucial piece of this, yes. The state said Glossip had Van Treese killed to cover up the fact that he was stealing from the motel.
So to defend himself, Glossip would need
the financial records, of course.
And what happened to them?
The current Attorney General's investigation confirmed the state engaged in the destruction of evidence, including those exact records.
Unbelievable. So how can he defend himself against the primary motive when the state has destroyed the only proof?
He can't.
Yeah.
He completely guts his ability to mount a defense from the very beginning.
Okay, so let's fast forward. After all this comes out, the Oklahoma Attorney General does something pretty incredible. He confesses error. He basically goes to the court and says, "We messed up. We violated NAPU. Give him a new trial."
A truly extraordinary moment of accountability. But the system, it pushed back hard.
The OCCA, the Oklahoma Court of Criminal Appeals.
Right. The state's highest criminal court, they just denied the petition. They said the claims were procedurally barred.
So basically you're too late, or you filled out the wrong form, so we're not even going to look at the constitutional problem.
That's it in a nutshell. They were using their own local rules as a shield to block a federal review.
Which is a huge problem for SCOTUS. They usually can't step in if a state court decision rests on an independent and adequate state ground.
A perfect way to put it. So SCOTUS had to decide if that shield was legit. And they found that it was not independent.
Why not?
Because the OCCA only decided to use that procedural bar after they first decided that the federal constitutional error, the NAPU violation, wasn't real.
Oh, I see. So their logic was, the federal error isn't real, therefore our local rule applies.
Precisely. And since their use of the local rule depended on them getting the federal law wrong, SCOTUS said the state ground wasn't truly independent and they could step in.
Which brings us to the final ruling.
The final ruling. SCOTUS reverses the OCCA. They confirm the prosecution violated the due process clause by letting Sneed's false testimony stand. Glossip gets a new trial.
And they specifically ordered a new trial, right? Not just another hearing.
A new trial is the only appropriate remedy. When you destroy confidence in the sole witness, you have to start over.
What I find fascinating is that the court didn't just point to the one lie. They brought up a whole pattern of misconduct, this idea of cumulative error.
Yes, if you connect the dots, you see a total system failure. We already mentioned the destroyed financial records.
Right.
But there was also strong evidence of a sequestration violation. That's the rule that says witnesses can't talk to each other to coordinate their stories.
And what happened?
Evidence suggests the prosecutor talked to Sneed about his testimony on the knife mid-trial. It looks an awful lot like coaching, helping him get his story straight to match the forensics.
That is just deeply concerning. And then there were those withheld witness notes. Glossip had cash on him when he was arrested.
Right, and he always said it was from selling his possessions to hire a lawyer. The prosecution, of course, said it was stolen money.
But those notes...
The notes, which the defense never saw, had a witness telling police that Glossip had sold a TV and a couch for $900.
Which would have perfectly backed up his story.
Perfectly. It just torpedoes the prosecution's theft theory.
Yeah.
So it's not one thing. It's a compounding pattern of failures.
So to wrap this all up for you listening, this case is really a textbook example of why that NAPU rule, the rule against using false testimony, is just non-negotiable.
The integrity of the process is everything.
It shows that even a lie about something that seems minor, like a cold versus bipolar disorder, can be fatal to a conviction when the entire case hangs on that one person's credibility.
And it's a really potent reminder that the state, and only the state, has the burden to ensure a fair trial. That duty can't be delegated or ignored no matter how much time has passed.
So when you line all of it together, the destroyed evidence, the coaching allegations, the star witness who lied under oath, the real question isn't just whether Richard Glossip deserves a new trial. The deeper question is what this long train of institutional failure says about the justice system itself. You have to wonder, how many other convictions out there are resting on similar, uncorrected errors that just never happen to get exposed?
A provocative and, I think, a very necessary question to end on.
See you next time for the deep dive.